Thank you very much. Very happy to be here with you today. So let's get started with personal data and data privacy in Laos. Regarding the agenda and the subject that we will be talking about today, they do not change from what Jay actually talked about already. So part 1, legal and regulatory framework. Part 2, definition of personal data, but broadly key terms and stakeholders in electronic data privacy in Laos. Part 3, collecting and processing of personal data, duties and regarding the processing of personal data in Part 4 and Part 5 sections. So let's move on to the Part 1, the legal and regulatory framework in Laos. So this is actually the laws and regulation pertaining to electronic data broadly in Laos. So I would say in recent years, everything started with the law on electronic transaction in 2012. But that law was mainly destined to business, forming a contract on online, for instance, but also introduced some concepts like the consent, electronic consent by electronic means, and also electronic signature. So that was definitely a very important law, but that was very much limited in business contract and that kind of how to prove that a contract made online was valid. I believe that one of the very important law that came right after, I mean, in 2015, is the law on cybercrime, which is often cited for even personal data and data privacy law. But the thing is that the law on cybercrime provides legal means to sanction cybercrimes. And here, when we talk about cybercrimes, it could be unauthorized access to a computer, stealing data, which could be personal data or data from a company or whatsoever. And there was also, and there is still also actually a focus on social media and the use of personal information or the use of social media generally to tarnish the reputation of someone. But this law on cybercrime didn't provide any set of standards to address the administration of data or to address whether or not the consent is required in several situations. So these standards of how to administrate data and electronic data, so to speak, came in 2017 with the law on electronic data protection and 2018 with the instructions on the implementation of the law on electronic data protection. So one who is a little bit familiar with Lao law knows that usually there is a law that is approved by the National Assembly, but most of the time the law will be too general to be implemented effectively. Therefore, there is most of the time, if not all the time, a subsequent regulation that would be required in order to explain better the law and to implement the law appropriately in practice. So that's why the instruction on the implementation of the law on electronic data protection was actually issued and published in Laos. So that those instructions provide a lot of practical examples, maybe, to explain further the law on electronic data protection. So from now on, actually, we will be focusing on the law on electronic data protection only. So what are the objectives of the law on electronic data protection? So first of all, I would say it was to update a legal framework which was outdated, which didn't take into account the advance of internet generally, but also applications, e-commerce. Secondly, it was, as I just said, to provide eventually a legal framework on the protection, processing of electronic data and personal data, because the previous laws didn't address that issue at all. And thirdly, I would say to align the local regulation, the local laws with regional standards. I don't talk about international standard because I do believe we're still far away from the general data privacy regulation that we have, for instance, in Europe, or even more recently, the Data Privacy Act in Thailand. But definitely Laos is trying to catch up on the regional frameworks and agreement that actually are set out below here. And accordingly, Laos is trying to improve its legal framework, and that's why the law on electronic data protection was also issued. So according to those regional framework you can see below, I want to warn that these Asian framework are not binding at all, and they do not set any obligation on Laos of any sort, but they should be regarded as a series of regulation or agreements, framework that provide some direction or guidance to Laos, and that could provide us also a sense on how to anticipate how Laos will actually improve its current legal framework in the near future. Moving on, so part 2, definition of personal data and stakeholders in data privacy. So here, more than just providing one definition of personal data, we would like to set out the key definition of the key terms under the law on electronic data protection. So obviously we need to start with electronic data because we're talking about the law on electronic data protection. So electronic data, according to the law on electronic data protections, means any numbers, letters, whatsoever information you have actually on your computer will be deemed as electronic data. This sounds very obvious to say, but I think it's very good to point out that the law on electronic data protection, even though addresses data privacy issues, only address issues pertaining to electronic data only. So what I mean is that those notes or records you have on the paper are not concerned by the law on electronic data protection. Second key term, I do believe, is personal data, which has a very broad definition. So according to the law on data protection, electronic data means electronic data of individual, legal entity, and organization. So here again, there is a good information just by reading the definition is that personal data in Laos does not concern only individual. So there is no comprehensive legal framework for personal data for individual in the Lao law. And the other definition, which will be very important here when we read the law on electronic data protection, is information owner, which could be referred to data subject maybe under the GDPR whenever we refer to individual. And here, information owner again is defined as individual, legal entity, and or organization which is the owner of the electronic data. So somehow the definition here is a little bit confusing because the information owner does not relate to an identifiable person, but relates to someone or an organization who owns the electronic data. So sometimes it's pretty difficult to actually clearly foresee who may be deemed as a information owner according to the law. And the last key terms, I believe, that we have to talk about is data administrator, which you may refer to data processor maybe under the GDPR, or those more familiar also with the Thailand Privacy Act. So data administrator is individual, legal entity, and organization which has the duty to administrate electronic data. And the law provides also a couple of practical examples that are deemed automatically as data administration under the law: ministry, internet data center, telecommunication service provider, internet service provider, and banks. So no matter what these are, will be considered a data administrator. But I think there is a little bit of downside in the definition provided here, because it's pretty challenging to actually foresee who may fall under the list, who may fall under the definition of data administrator. Here, the practical examples are non-exhaustive, and the definition provided, organization which has the duty to administrate electronic data, is kind of broad. What we may understand, however, according to the definition provided, is that the amount of data that a entity will have to treat or administrate and the level of sensitivity of the data may help or assist in defining someone or a company as a data administrator. For instance, even though here we don't talk about insurance company, I do believe that it's most likely that the regulator or the legislator will consider an insurance company as a data administrator. And this is very important because there will be additional obligation that will be vested upon the data administrator under the law. Competent authority, I will try to be brief on that one. So Ministry of Technology and Communication, it was newly renamed actually just even 1 month ago or so. It was still the Ministry of Post and Telecommunication. So this is the ministry that is in charge of about all the issues pertaining to electronic data or even ICT activities in Laos. And this is also the ministry that issued those instructions or subsequent regulation pertaining to electronic data in Laos. And secondly, I would name also the Laos Computer Emergency Response Team, but this one is more a group of people with technical skills and capability who are here to counter cybersecurity threat. But if you are or someone in Laos is actually subject to data breach or any breach of personal data, they can go and complain also to the Laos Computer Emergency Response Team, but they will be more likely to provide technical assistance rather than anything else. Moving on, part 3, collecting and processing of personal data in Laos. So this is what is very important actually in Laos whenever you want to collect data. So at the time of the collection, at the time you want to collect data or somebody wants to collect data, the information owner or the data subject, if you may, must be provided with information about the purpose of the collect of the data. So you have to explain clearly for what reason the data is actually collected. Also, what information will be collected. Who is the data administrator, if there is one. So if there is one, you must provide the identity of the data administrator, where the information is stored. And this one is particularly important, and maybe that's the only reason why it's important. In the event that you wish to transfer the data outside of Laos, you must expressly and information beyond that. And how the information owner can access its information, this is also another very important requirement, because as for Cambodia, we've just seen it, there is a couple of rights also granted to any information owner relating to the data collected and stored by the data administrator or someone else. Moving on. So, as I explained just earlier, the Lao legal framework has no comprehensive personal data protection provisions in the electronic data protection. This is because actually the electronic data protection law treats personal data as any kind of data. So depending on the nature of the data, the personal data will be considered or fall into one of the 3 categories that the law on electronic data protection has for data. So there is general data, which according to the electronic protection law, data electronic protection law, it's information that can be accessed, used, and disseminated, but the source of the information must be clearly indicated. The law also as well, not the law here, but the instruction provide also a practical example to help out people to understand what may mean general data. And here in my slides, I do put all the practical example provided in the law. As you can see, the list is not exhaustive. Then we have sensitive data, which is data that actually cannot be accessed, used, or disseminated if the person actually handling those data did not receive the consent from the information owner. And here again, the regulator has provided a practical example to help out. So we can see here a couple of examples provided in order to help out people, to assist people to understand whether or not the data we are talking about may be a sensitive data or not. So here, regarding personal data, we could name history of medical treatment, race, religion, and there are some other information that are not related to actually personal data. And finally, and this is how we call it because it's not provided in the law as such, but we call it prohibited data because there is in the law on electronic data protection, there is a category of data which is strictly prohibited from being electronically administrated. So these are information, this is information concerning race, ethnic, political opinion, religious belief, sexual behavior, criminal records, health information, or any other information that may affect the stability of the nation. So I guess you already noticed that there are some information overlapping between sensitive data and prohibited data. And I agree with you, that's something that should be clarified further by the regulator. But regardless of the category of data we are talking about, anytime someone wants to actually collect the data, the consent of the information owner must be granted. Otherwise, it's not possible. Moving forward. So here it's about the rights of the information owner. So as I just said earlier, even though the data has been collected by someone, the information owner still has rights on it. Okay, so here, for instance, I name, according to the law, four rights, sorry. So you have the rights to access the information. So anytime the information owner can actually request to access the information just to verify the information, the right to stop the transfer of its data, which means, for instance, the information owner can ask to stop to transfer any data to some marketing, third-party marketing partner. That's something possible. The right to delete information also as well is something provided under the law on electronic data protection, and the right to correction, as we've seen also in Cambodia. So these rights actually, those requests must be addressed to the data administrator, so that's what the law says. And there is no specific time frame in which the data administrator should operate any change regarding to this type of data. But there is one thing that the law on electronic data protection says is that in the event that the data administrator cannot treat or handle the request of the information owner, it must inform the information owner accordingly. But again, there is no specific time frame wherein the data administrator must proceed with the change requested by the information owner. On a side note, for those of you who are familiar with the GDPR or the Thai Privacy Act, I would like to say, so even though we do have a dedicated electronic data protection law in Laos, this is not a personal data protection law. So accordingly, as you can see in the right side of my slide, there is no data protection officer under Lao law that is required. So there is no officer that must be registered with some kind of national data authority. That could be the case in some other jurisdiction. But the law provides that any data administrator must have a team or an employee that supervises the protection of sensitive data specifically. There is no condition requirements about the level of education of that employee, but this is something that is required. Also, we do not know if that employee could be based offshore, maybe outside of Laos, or should be based in Laos. The law does not say nothing about it. And finally, regarding that data administrator, I mean, the requirement, there is no mandatory breach notification in Laos. So it's a little bit confusing when we read the law, but we ask some confirmation from the authorities in this regard. And the breach notification is actually voluntarily. So which means that if you have any issues, indeed, you need to inform the Lao cert as we talked before. And then the law also would provide you with technical assistance, but there is no requirement for companies, for instance, to inform the authorities of a data breach regarding some time of data breach, some type of data breach, or according to the quantity of data which were breached or so forth. So there is no such requirements in the law. Moving forward to the next slides. So here, just a couple of recommendations, but I think is more summarizing what we've said. So whenever someone collect data, please do make sure that the data is collected with the consent of the information owner. The purpose of the collect is very clear. We could not deceive the information owner in providing its consent. The identity of the data administrator, if any, is provided. The rights of the information owner are also provided. So the information owner should know about his rights, also or her rights, what he or she can do. The information must be correct, and this is a little bit tricky because actually the information is correct according to the law, both sides. So the information owner and the data administrator must verify that the information is correct, and the information is stored for as long as required according to the objective of the collect. So do not store the information for a longer period, which would not be legitimate. Also, as an employer, and many of you, I guess, are employees here, you have to make sure that you have also the consent of your employee whenever you collect, store, use, transfer data of your employees. So this could be also specified in the employment agreement, for instance. Moving on, I will be probably rather brief on this one. Security measures. So the law on electronic data protection set out a list of measures that data administrator must ensure. I would like to add, similarly to Cambodia, there are some regulation or law that are specific to some industry. For instance, here I do not mention service payment, but there were a couple of regulation, even laws issued during 2020 in Laos that concern specifically service payment providers, and they may also need to abide by a specific obligation relating to security measures. So here are the measure, the main measure that we have raised in these slides pertaining to electronic data protection law. So you must have, as a data administrator, a responsible of sensitive information, adequate system to store or use the data without any further information in this regard, a backup system, record information by another appropriate method. So this is the law provides, for instance, paper, magnetic storage, have a risk assessments once a year at least, and inspect access to system and so forth. Also, one thing that we would like to clarify, and I think it's very important because, as I said in the beginning, data administrator definition is very ambiguous. So if you have a contract, a service contract with a data administrator between your company, for instance, and the data administrator. So I believe that that's where you should make it clear who is a data administrator, but that's also where you should make it clear the responsibility of each. Who is a data administrator indeed, but also what are your responsibilities and what are the responsibilities of a data administrator. Also, the security measures that must be in place or the standard that you would expect from the data administrator, and also who may be liable in the event that an equipment fails. We should be the one to fix it, for instance. That sounds pretty obvious, but believe me, that happens a lot. So part 5, and I will finish on this, and it's very brief in Laos, according to the law on electronic data protection. So this is some kind of wording that we find often. So the law on electronic data protection provides some fines in the event that you breach the law. And for the rest, it actually depends on the nature of the offense. So maybe the authorities give them some leeway to adjust the sanction accordingly. But what we would like to say also as well is that in Laos, there was no any kind of trend to date or relevant trend pertaining to any issue brought to the court relating to electronic data protection or data breach generally. So today it's pretty difficult even to talk about any precedents or trend in decision of justice in this respect. So that would be it for me, at least for Laos. The question. So I would say a very short answer, it would be no, because according to the scope of the law on electronic data protection, it's very clear that the law applies to company based and operating in Laos. But in any case, as I mentioned during the presentation, you have also to remember that there are some requirement that may apply to anyway. For instance, we clearly say that in the event that personal data or data has to be transferred from Laos to foreign countries, actually it could be foreign companies too, but foreign countries, then the information owner should be expressly informed about this. And the other thing that we found a lot actually is that most of the time, many foreign-based companies, they do have a distributor in Laos which will collect information on their behalf. So this company based offshore or to another business partner based offshore, that local distributor, whoever it is, that local partner will have to abide by the rules of the law on electronic data protection. So this is very important that these local partner follow strictly the rules on requiring the consent and so forth. And also there may be additional obligation that fall upon that local partner in the event that that local partner is considered as a data administrator also as well. So I would say no, but for some instances, the law may still apply also as well. Very difficult because, as said during the presentation, there is no official guidance in this respect, and I believe that the most thing that you could do actually, if you do store some health information regarding to some person and you store those electronically, that to be sure that you have the consent in regard to this information that you're actually storing. Now, by law, prohibited data cannot be stored or processed at all, and that's the issue. I do believe, for instance, that this provision of the law, and I didn't want to linger too much during the presentation, but this provision of the law is definitely too strict and does not provide any flexibility to business operators on the grounds to try to develop activities which are based actually on electronic data. So I would say that would be very important that your company do have an internal guideline just to ensure that you do have internal policy that provide enough security, safety relating to the data you do actually store electronically, so that in the event that the government may ask you some question about these type of data you're actually storing, you can good face also as well that the law is ambiguous, but on your side, you're doing your best to actually ensure the security of the data you're storing. Now, I would say by law, it sounds very strict. So I would say that for data, it's very difficult today in Laos to legally process that type of data. And even for sensitive data, it's the difference between health data and history of treatment, of medical treatment, is very ambiguous also as well. And we didn't receive any clarification in this respect from the government.